everybody. Rob Seaver, Executive Director with Leads Counsel. I'm bringing you a very special edition of our on-air podcast. This one has a whole lot of cool things happening. We're going to get down and dirty, but I'd like to just quickly introduce my guest, AC Evans from drips.com, Eric Troutman. You know him from TCPAworld.com. Guys, thank you for joining me on this day. Obviously, we've got something to dive deep into very quickly. I'm going to kick off with you, Eric Troutman. You are the man. You've already broke this story. Help me understand what just happened.
Sure. So this is huge. And Rob, I want you to know I'm coming to your viewers first. I've got Politico on hold here in a couple of hours, Law 360. Everyone's beating down my door. But I want to start with you because Leads Counsel now has a critical role to play, more critical than ever before. But let's break it down. Here's what happened. The Supreme Court just decided the Facebook appeal of the TCPA's ATDS definition. You might remember, everybody, that there was a huge split of authority. What does the TCPA cover? That turns on the definition of an automatic telephone dialing system, an ATDS. The TCPA has a very specific definition, but the courts were largely ignoring that definition, expanding the TCPA to apply to all automated technology. Well, today, in a 9-0 unanimous decision, the United States Supreme Court held that the TCPA says exactly what it means, and that the TCPA only applies to systems with the capacity to store or produce numbers, here it is, using a random or sequential number generator. If the system that you are using to call consumers, to call cell phones, to call people, does not have the capacity to store or produce numbers using a random or sequential number generator, the TCPA does not apply to you. And yes, that means, technically speaking, under federal law, under the TCPA, you can call folks on their cell phones without consent starting right now. If you are sure that your system lacks that capacity.
If you're sure.
That's what happened. But there's more to it, of course, but go ahead, Rob.
I heard the capacity word that has been in play for a while now. Before I steal all the thunder from the other guest here, AC Evans, Vice President of Leads Counsel. Obviously, we track this on a regular basis. You and I staying, connected on this stuff. You running drips.com, premier eminent text platform out there. What does this mean for you? Obviously, texting was at the center of all of this.
Yeah, I can say in the short term, nothing changes, right? For us, I think our best practices stand. I expect the same from the companies that we work with, which are all the large companies out there, the companies that Eric represents. I expect nothing's going to change for them. I don't expect people are going to remove their checkboxes from their forms, even though, Eric, correct me if I'm wrong, but they technically could at this moment, which is interesting. But yeah, nothing changes for us, Rob. Still going to lead with best practices, consumer first, methodologies, and work with the companies that are going to do right. Of course, we're going to work with Eric and the Leads Counsel to track this, and see how it goes, because I think Eric will share with us today that nothing is ever final or finite. But yeah, business as usual for us. Keep doing the right thing.
So, Eric, Marks v. Crunch, Ninth Circuit, been used in a lot of the things that you've reported on TCPAworld.com. Help me understand, is that gone, or is it just flavored differently, or will it crop back up, especially with the capacity word?
Yeah, it's gone, probably. Okay, so what the Supreme Court did,
true attorney.
right? Well, this is the TCPA, right? It lives on forever, so you have to be careful with how you frame things. What the Supreme Court did was say that that an ATDS must do something specific. Okay, what it must do is use a random or sequential number generator in some way. What the Supreme Court didn't do was address this goofy word capacity, which means at least some courts out there are not going to look at how the system was actually being deployed in the moment. They're going to look at, can the system be configured? Can it operate in a way that makes use of a random or sequential number generator? Now, the net effect of all of this, though, is that probably 90%, maybe 95% of courts will now look at most platforms and say, this is not an ATDS. But oh, that 5%.
Quick question.
Go ahead, AC.
Sorry, Rob. I was just a question, or just to dumb it all the way down, Eric, and correct me if I'm wrong, but I think what they've said and what we thought the TCPA was meant to be was to truly stop scammers and spammers, right? The people that are hitting us up every day, all those missed calls from, whatever it may be, company trying to sell you something or consolidate your debt, that they actually did do the random or the sequential. Is that accurate, Eric?
Well, it's accurate to a degree. The Supreme Court did not rule based on content, right? So it wasn't looking at spamming and scamming per se, but you are correct that it was looking at the mechanism by which the calls are being sent. And it is true that scammers and spammers are much more likely to use random fire dialing, at least in the past, right? This ruling does enable people, again, in theory, frankly, to become less good actors, right? It's great to hear that DRIPS is kind of staying the course and wanting to provide best practices and industry leadership, because really this is a critical moment. And I started my comments, Rob, by saying that this is a moment when leads counsel becomes more important than ever before. And the reason is that industry and calling groups now have more power than they've had. They have more leeway, right? I just hope it's not enough rope to hang themselves. And by that I mean, if folks get out there, crank up the dialer, and start misbehaving, right? Because the TCPA is now kind of, it's a genie back in the bottle in 95% of the courts. It's not going to hurt you anymore, okay, in 95% of courts. If the industry response to this is to just crank up the dialer and start trying to pitch water bottles and ping pong tables to Americans, just dialing random phone numbers or dialing from a list of phone numbers, right? There is going to be an extreme backlash, and not just from Congress, but from the states. And I'm talking about completely barring telemarketing calls, right? Things like that we've already seen kind of starting to take shape in nascent form in certain locations. Industry has got to self-regulate. They've got to self-police. And good companies like DRIPS, and of course your organization, Rob, Leads Counsel, they are the shining light on the hill, and they just have to get it together starting right now. Otherwise, I'm telling you, when that other shoe drops, we're all going to miss the TCPA.
I mean, Eric, we've heard this now for a while from these legislators that, they're working on it anyway. And so you were on the stage in Colorado last year with a state senator, and he made it very clear they're working on anti-telemarketing, anti-robocall legislation. And that's something we've heard from every state. So this is not something new. AC, you've been in this industry for a long time. You're obviously, in the tech side, but do you think that this is going to turn a lot of companies' heads in the wrong direction? Do you anticipate a lot of bad actors coming to the surface as a result of this, or what's your crystal ball on all of this?
Absolutely. I think the people that were gray hat, if you will, are going to do more of that. I think the companies that already had, strong best practices, all the enterprises that are involved in Leads Counsel are likely going to stay the course. But I think it's going to make room for a lot of, a lot of bad behavior, right? I mean, again, you can now push out a lot of calls and a lot of messages without prior express written consent. Essentially, you can just get somebody's phone number. That's easy to get. It's harder to get when you put the check boxes and the radio boxes and the disclosures and all that stuff. It makes it much harder to get those lead captures. So I think you're going to see a big swell in traffic from the publisher world. I think some of the enterprises are probably going to accept a lot of that traffic. And Eric, you tell me where the liability really falls, but that's what I would expect. I would expect like the heavier affiliate marketing, publisher marketing, and platforms that some of them use are gonna double down on this, right? It's almost like if Gmail said, great, you can hit inbox, no questions asked, email will go on the rise, right? And if you didn't need an unsubscribe link and canned spam got revoked or whatever, there would be a lot more email marketing going on. So I expect that same behavior.
Eric, I read everything you've written this morning, and I commend you for having the capacity to write for the industry. So thank you very much. But there are a couple of things that I think that you pointed out that were interesting to me. One, human intervention. You made that something that you pointed out specifically because that's come up in prior cases, and you believe it's going to play a big role, I think, moving forward. And then you also pointed out that TCPA is not the only law of the land, and you've said that earlier in some capacity. But we have Traced Act in June, right? And that's been around. But I mean, obviously, we have these thresholds that are going to come into play. So really, TCPA, albeit as important as it is to the industry, the human intervention part, the definition of capacity, the other laws on the books, really, has anything changed?
Well, something has changed. I mean, it would be, you don't want to undersell the development of Facebook. It's a huge deal, and it's a huge deal, particularly from a litigation shield perspective. For a number of reasons, though, right? This should not be a sea change in terms of practices. All right. So if you get sued, yeah, something's changed. You've got a 95% chance of defeating this lawsuit now. So that's a really good thing. But from a different perspective, the TCPA is not the only law on the books, right? You've got a number of additional laws, and there's going to be more if industry does not participate, again, in a good, responsible way. But it's important to realize also, just kind of hit the pause button, that today's ruling looks at only one piece of the TCPA, which is the ATDS definition. Pre-recorded calls, please understand, everybody listening to me, pre-recorded calls are still subject to the TCPA, okay? So if you're using pre-recorded calls, IVR, ringless voicemails, anything like that, even if somebody's pushing a button, right, in order to leave that voicemail, nothing changes. That is still subject to the TCPA. You still have to have that express written consent, okay? DNC calls, right, still subject to the TCPA. It doesn't matter if these are manually called, using a dialer, or pre-recorded. If you are contacting a cell phone that is a residential line that is on the DNC, you have to have express consent or an inquiry or an established business relationship with those people. You cannot just engage in a telephone solicitation, even despite what Facebook just held, okay? So, I heard what you said earlier, AC, and I agree with you that there's going to be actors out there, publishers, affiliates, whoever, right, that are going to double down. They're going to make use of this development, and you know what? Maybe they should, okay, as long as they do it responsibly. But everybody has to keep in mind that although this is a change, it is not, I'm not going to undersell this. Facebook matters, but it's not a complete alteration of the entire framework of telemarketing law in this country. There are a lot of other pieces that everybody needs to keep in mind. And again, if you don't act responsibly as an industry participant, if the industry together doesn't come behind best practices that groups like Leads Council hopefully will put out, trust me, what comes next will be much worse than the TCPA.
Well, there's
a lot.
Yeah, go ahead, AC.
Sorry, Rob. I was just going to say, I don't know if you see this as well, Eric, but I just think there's so much changing and so many things finally falling into place, right? I mean, you got the Apple versus Facebook stuff with tracking on here. You got Google killing third-party cookies. You got this now. Like there's a lot of stuff that is that is coming into play, and it's all happening very, very quickly.
I think, as you know, AC, the council is working fast and hard at developing not only a self-regulating program that we can certify through third-party audits and things of that nature and self-attestation, whatever the word is, but at the end of the day, we have a plan for bringing people into the light and making it an easier choice of who to buy from, who to sell to, and things of that nature. And that is the mission of the council. And so I think things like what happened today are natural courses for why we're heading in that direction and ultimately what we represent to the industry. But, I'm not going to take up much more of your time. I wanted to get this out. I wanted to get some real explanation of what was going on. Here's the question to both of you, and I'll start with AC, and then I know that Eric will jump right on this. Are we going to be able to prove to regulators that we're an industry capable of self-regulating, capable of doing the right things? Will the legislators and regulators out there finally see that, hey, there is an industry organization out there capable of regulating the industry at a level that's going to protect consumers. And AC, do you believe that the council is in the right position, heading toward the right direction, and capable of executing on this? I just want to hear
Yes, I mean,
here.
Yeah, as you said, I mean, we've both been on all these calls talking about the SRO, figuring out what the common denominators are across the industries. I mean, we know it's a tough nut to crack. It's an enigma to solve. But I think we've made, specifically over the last couple of months, more traction than I think I've seen in the last couple of years. So yeah, I think we're on the right path. I think things like this help expedite that path, right? Because as Eric said, it becomes more important than ever. We had, like I said, things like the cookies being killed from Google. We got 10 DLC coming down, the campaign registry. When you're talking about my world, that's going to add more and more transparency. You're going to have to prove your use case. Just because the Supreme Court doesn't say you have to do it a certain way doesn't mean that AT&T, T-Mobile, Verizon, and Sprint won't. Right. So I think the SRO is of the utmost importance, and agreeing on best practices that are, putting the consumer first has to happen, or otherwise, as Eric said, something much worse comes next.
Eric, I want to put a different spin to your answer. As a counsel to all of these organizations, what do you think that the typical counsel is going to say to that lead gen company today after this ruling? And what do you feel like the next 3 to 6 months is going to be in this industry as a result of it? And what are you recommending to your clients?
Well, I'm going to answer that, but I want to answer your first question too, which is whether or not you do it, right? Whether or not leads counsel is going to take the leadership role, and whether or not your members and boards and folks in this industry are going to agree to self-regulate. I mean, the proof is going to be in the pudding, but you got to do it. I mean, the time for talk is over. It's time to get it done, because I am telling you, if industry goes berserk, you are going to rue the day. You are going to wish that you had gotten together and set standards. All right. So moving to, what are folks going to say about this ruling to their clients? My job first and foremost is to protect my clients. It is to make sure that they are informed and knowledgeable so that they can make intelligent decisions. Now, different clients are going to have different risk appetites. They're going to do different things. But my job as their counsel is to make sure that they understand what that risk looks like and to help them protect themselves, right? That's my job. Do other lawyers engage in different practices? I don't know, right? It's difficult for me to understand what other attorneys might be telling different industry participants. It would not surprise me if some folks were saying, hey, guess what? You can go out there and hammer people now. I hope that that's not happening, but I'm sure that it is, right, in certain corners of this industry. But from my perspective is what we have been given in Facebook is a great gift, right? But again, it is rope that we might use as an industry to hang ourselves if we're not cautious, if we're not intelligent and thoughtful about how we want to deploy it. I think the way it should be looked at, my opinion is, at least at this moment, right, 2 hours from the decision being handed down, is that it should not be viewed as something that changes your compliance practices. It should be viewed as a great protection in litigation, so that if you get sued, you now have a great tool to defend yourself. And that's good for everybody, right? But it should not change your practices. And fundamentally, it doesn't change the reality that consumers want to have their contact preferences honored, and that they'll do business with people and buy products from folks that communicate with them in the way that they want to be communicated with.
From the lips of Eric Troutman, the czar of TCPAworld.com, time for talk is over. I'm going to take that. I'm probably going to put that somewhere in big words. I think that's the words of the day. Listen, guys, thank you very much. I know that you're in much demand down there, Eric Troutman, and AC. You're always busy, so I love having a little bit of your time this morning. Thank you guys for joining me and giving this important update for the industry. It's a big day.
Absolutely.
Thanks so much, Rob.
All right, guys. Thanks. All right.